You're listening to an Airwave Media Podcast.
Virginia is one of these states that still has a poll tax. And what they do is say, okay, we're not going to put a tax on the vote. We're not going to make you pay a tax to vote at the polls. But we're going to require a certificate of residence. And it's going to cost a fee. Today's show is brought to you by Vanguard. As we step into a new year, it's the perfect time for all the advisors listening to think about how to set up your clients for success. One way to do that is to level up your fixed income strategy. But bonds are tricky. The market is huge. Rates shift, and risks hide in plain sight. That's why having a partner with scale and expertise matters. Vanguard brings both. Lots of firms love to highlight their star portfolio managers. Like it's all about one brilliant mind making the magic happen. Vanguard's philosophy is a little different. They believe the best active strategy shouldn't be locked away with one person. They should be shared across the team. That way, every client benefits from the collective brainpower. So, if you're looking to give your clients consistent results, year in and year out, go see the record for yourself at Vanguard.com/audio. That's Vanguard.com/audio. All investing is subject to risk. Vanguard Marketing Corporation, distributor. In 1962, the House passed the 24th Amendment, outlawing the poll tax. It is not the most well-known amendment. People barely ever talk about it. It really is going to affect 5 states by the time it's passed: Virginia, Alabama, Mississippi, Arkansas, and Texas. These states have what could be identified as a Jim Crow law of the post-Reconstruction South. In the 1890s, really the 1880s, these laws start developing to place a poll tax, sometimes quite significant, on people who are voting, as a way, as some proponents have revealed in private letters and things like that, to disenfranchise African American voters. It's an odd amendment in a lot of ways, the 24th. It is also could be considered an achievement of John F. Kennedy. We don't talk about his achievements a lot because he was a person that suffered a tragedy and was only president for 3 years. We tend to say that all the achievement went to Lyndon Johnson, but this was actually finished and passed while he was still president. And while presidents don't directly sign amendments to the Constitution, it's actually a joint resolution of the Senate and the House, then goes out to the states, then comes back to the Secretary of State and the Archivist in order to be considered an amendment and added to the Constitution. The president doesn't actually sign it. However, Kennedy had pushed for it and had advocated it, and there is a plank in the 1960 Democratic Party platform that pushes for a vague reference about voting rights and then a specific reference, the elimination of the poll tax. And it's kind of brave because those 5 states we just mentioned are states that the Kennedy-Johnson campaign were targeting in this election. In November of 1962, Illinois is the first state to pass the 24th Amendment. New Jersey follows, Oregon follows, Montana follows, West Virginia follows, New York follows, Maryland follows. It's interesting, though, you're seeing a pattern there. These are all northern states passing an amendment that's going to affect the South: Indiana, Utah, Rhode Island, Michigan, Ohio, Colorado, Minnesota, New Mexico, Hawaii, Washington, Vermont. And it's not until April 1963 when you get Florida to ratify the 24th Amendment. And there's a specific reason for that.
I just feel like that they might have a real meaning to you, me, and everybody else.
And that is Senator Holland. Spessard Holland. And Spessard Holland and John F. Kennedy could not have been more different in terms of their policies. They are both Democrats, and Holland did end up begrudgingly supporting the Kennedy-Johnson ticket. He was a New Deal Democrat in Florida, but also a segregationist. And on every other voting rights piece of legislation, anything that would have the federal government imposing on what the state of Florida could do, Spessard Holland was against it. He signs the Southern Manifesto in 1956. This is essentially a group of Southern politicians signing that they will do everything to not only oppose but resist the Brown versus the Board of Ed decision of the Supreme Court of the United States. And yet, Holland partners with John F. Kennedy and others to pass this amendment, which would increase the amount of voting.
Well, do everything you can, Mr. President. I'm immensely interested. So is George and Paul and all of us. And if you can do it, well, we'll appreciate it more than anything you can do.
At the Democratic Convention in 1956, John Kennedy runs for vice president. And it's his real first national move. He's campaigning against Estes Kefauver, who's from Tennessee and who is a Southerner then. But Southern Democrats don't like this particular Southerner so much because he had been for civil rights. And while we don't see Holland necessarily pushing for Kennedy directly like that, Kennedy was navigating and got support from Southern power brokers at that convention, but he didn't get enough to win the vice presidential nomination. Possibly good for him. So he reaches the presidency in 1961, still needs Southern Democrats to govern. He cannot be just, giving the hand just because he's a little more liberal than some of the Southerners. The Kennedy margin is very tight in Congress. He's working with Sam Rayburn. He's trying to get things passed. Southerners still control most of the finance committees and anything related to segregation or civil rights. Now, Holland, it should be said, although he's not he's a segregationist. He's not a bomb thrower. He's not a Strom Thurmond type. He's not going to sit up there and make long speeches and filibuster and things like that. And he kind of knows where America's going. By the 1960s, one of the most visible symbols of disenfranchisement is the fact that you put a fee on Americans voting. And every time they try to eliminate the poll tax by a statute, this is a Kennedy platform. He wins the election. Maybe you should push for this. Go to Congress. They run up against resistance. So actually, and you don't see this too much today, instead of going for a statute because it's too hard, because Southerners choke the congressional committee so the bills can't even get out, we go to a constitutional amendment. Holland steps forward. He becomes the sponsor of the 24th Amendment. So it's a little easier for someone like a Holland or others to vote for a bill that merely sends it out to the states and let them ratify it than to actually vote a actual statute out of Congress. Because if you're against it, you're against the American people having a vote on this. And there's another thing going on, too. A lot of these, segregationist senators who had signed that Southern Manifesto, they don't like the way they're looking in the press. And so Holland, like a lot of them, is looking for something that they can point to that says, hey, I'm not against civil rights. I'm just against, and this is his opinion, not mine, changing the society of my state. Not against civil rights. Here's something that's wrong, and actually it applies to all people, and it's wrong. The arguments for poll tax, by the way, one of them that's probably the strongest is that this is the way that some of these states funded elections. So, elections aren't free to fund. Right now, they are free, if they have to be free, but they're not free. Someone must work the polls, run the ballot machines and things like that. And in many of these states, that poll tax is what funded the election apparatus. So the 24th Amendment passes. There are only 3 more after that is ratified in 1963. There's only 3 more amendments added to the Constitution. So even though it's a long time ago now, it's one of the few times that there was a national force to move and change something. And we don't tend to think about like the amendments in the 20s as being rights. You hear a lot about the first and you hear an awful lot about the second, of course. Once in a while, you'll hear about the 14th and you'll certainly, hear something about the Fifth Amendment, right? You don't hear a lot about the 24th, like as a right, but it's, rights or rights or amendments are amendments. They're both in the Constitution and they have all of that constitutional force, which is a higher level of law. I mean, you really can't make a law to oppose it. So you got a couple of cases, though, where this is tested. And one of them is Burdick, considering voting in an election and gets the ballot and knows there's only one person running. Okay, then I want to write in a candidate. And before the election even occurs, sues the state of Hawaii because they have no write-in vote. And this goes to the court and it tests the principle of, wait a second, you are putting a limit on my right to vote. It's not seen as substantial enough by the Supreme Court to move forward. And it does create a test which is going to come later. But the first case that is applying to the newly passed amendment is Harmon versus Forsenius. And this is because the first thing, Virginia is one of these states that still has a poll tax. And what they do is say, okay, we're not going to put a tax on the vote. We're not going to make you pay a tax to vote at the polls, but we're going to require a certificate of residence. And it's going to cost a fee. And the Supreme Court in Harmon versus Forsenius said this is not constitutional anymore. It violates the 24th Amendment. They actually think it violates the 14th, but it puts a material burden on the voter. And it says you cannot work around the 24th Amendment. I mean, eventually the court in a separate case, even without this amendment, is going to determine that you can't impose a poll tax on state elections because it violates the 14th, because it is an imposition on the rights of a United States citizen by a state. So that even gets thrown out. So you see the way this trend is going. And pretty much there isn't a huge amount of case law around the 24th Amendment, which we should read. It's not long. The right of the citizens of the United States to vote in any primary or other election for president or vice president, for electors for president or vice president, or for senator or representative in Congress shall not be denied or abridged by the United States or any state by reason of failure to pay any poll tax or other tax. So you have that plain text read right there. Black's Law Dictionary is going to be pretty clear that a fee charged by a government is a tax. If you have to pay it to do something, it's a duty. And then you have the case we just cited, which makes it clear there's no runarounds. You can't call it something different, and actually the language there, or other tax. Can't call it something different, like requiring a certificate of residence, and you need this to vote. You can't do it. And it should be settled law right there. I would love that we're now debating this Save America Act, which is going to require you to get a passport or some type of proof, have some proof of your citizenship available at the time of voting. I would love to be able to say that violates the 24th Amendment. Can't be done. And I personally think it does, but there's a reason it's not clear, and that's because there's been a recent court case in 2008, and it was a decision that was a fragmented decision when the court was a little more fragmented than it is now. And it was written by Justice John Stevens, and it's about Indiana's requirement of a voter ID to vote. So what we definitely know from that case, the Marion case, is that a requirement for voter ID is constitutional, at least according to that case. But Indiana did not charge for their ID. They had free IDs. They made it available to voters. It looked to Justice Stevens and the court majority as a reasonable, non-material burden. Well, there's also a concurrence in Marion. And, You can almost ignore the fact that the decision's written by Stevens, because at that point in the court, you would need at least one of the liberals or moderates to come along in order to have a decision that the conservative justices at the time, Alito was on the court, Thomas is on the court, Scalia is on the court. You'd need them. You'd need that Stevens vote in order to pass, because the liberals on the court at the time, Ginsburg and Souter and Breyer, were dissenting. But it's useful to look at Scalia's concurrence because, although he's passed away, his opinion represents a little bit more, and Alito did join, and Thomas did join his concurrence of where the majority on the court might be thinking now. I mean, what is really the majority in the court after that tariff decision? We don't really know what somebody like Gorsuch or Barrett or even Kavanaugh at times might do. And what Scalia does is go back to that case I mentioned in Hawaii, the Burdick case, and apply it to this issue of ID cards, and essentially say, well, what Burdick shows is that there's a two-tier system here. It's not just merely you can't make any imposition on the right to vote. We have strict scrutiny for things that are discriminatory, things that might be aimed at a certain population. And then for things that are more broad and are just kind of like inconveniences of voting, that's a much lower standard. Today's show is brought to you by Vanguard. As we step into a new year, it's the perfect time for all the advisors listening to think about how to set up your clients for success. One way to do that is to level up your fixed income strategy. But bonds are tricky. The market is huge. Rates shift, and risks hide in plain sight. That's why having a partner with scale and expertise matters. Vanguard brings both. Lots of firms love to highlight their star portfolio managers. Like it's all about one brilliant mind making the magic happen. Vanguard's philosophy is a little different. They believe the best active strategy shouldn't be locked away with one person. They should be shared across the team. That way, every client benefits from the collective brainpower. So, if you're looking to give your clients consistent results, year in and year out, go see the record for yourself at Vanguard.com/audio. That's Vanguard.com/audio. All investing is subject to risk. Vanguard Marketing Corporation, distributor. We'll redirect from Scalia. To evaluate a law respecting the right to vote, whether it governs voter qualifications, candidate selection, or the voting process, we use the approach set out in Burdick v. Takushi. This calls for the application of differential important regulatory interest standards for non-severe, non-discriminatory restrictions, reserving strict scrutiny for laws that severely restrict the right to vote. The lead opinion resists the import of Burdick by characterizing it as simply adopting the balancing approach. Strict scrutiny is only appropriate, Scalia says, if the burden is severe, and he's citing other court cases for this line. Thus, the first step is to decide whether a challenge law severely burdens the right to vote. Ordinary and widespread burdens, such as those requiring nominal effort of everyone, are not severe. So, for instance, in Burdick, we talked about Alan Burdick had sued Hawaii because he wasn't allowed to write in a name. Burdick, the court said that Hawaii imposed only a limited burden on voters' right to make free choices and to associate politically through the vote. I got a lot to say, but there's a lot of things about like Scalia's opinion. First of all, I mean, is he really right to apply the write-in voter case to a voter ID? I guess it is because it's about burdens, but there's a little creativity that not every judge, I believe, would agree with. But these are all, so, the point being, it's really going to come down to how a group of relatively conservative justices who aren't usually that far from Scalia opinion, what they're going to interpret what a substantial burden is or not. Now, strictly speaking, in my view, the cost of a passport, $130, when you don't have one, and many people do not have it. I mean, I think plaintiffs, if they sue on a constitutional case, could show stats about the percentage of Americans that don't have passports currently because it's not required. It's a document you need to leave the United States, and not everybody does that. Or some other type of proof of citizenship, maybe a birth certificate. Not everyone has that documentation available. I mean, sure, they should. And if they don't, there could be a fee. So it's going to come down to that burden. Now, if you're actually comparing the two cases, in the Marin case, the state of Indiana was offering free ID for those who didn't have, say, a driver's license. And a, driver's license versus passport, a little less cost, a little more common. Price of passport has gone up. The process is long. So I think you're going to have a challenge there in that, in terms of when you look at total burden, it's not just cost. It's also process that I have to go to. I meant to get a passport, I might have to take some time off work. And you're not giving me a lot of time to vote in the 2026 election. So I could see all those arguments playing out. I also think you have potential 14th and you have potential 10th because there's other elements of the Save America Act as it's constituted, which mandates that states hand over voter files to the federal government, which you could start looking at the 10th Amendment about. I'm not focusing as much on this because I wanted to talk a bit about that kind of forgotten amendment, the amendment banning the poll tax.
I hope you can do it.
I share your view in all those things. I've got problems. I've got some other commitments, and I've got problems even in connection with those. So
now, just so you say, I'm not some guy attacking, only one president or whatever. I want to talk about Lyndon Johnson and poll taxes because it's kind of interesting. When he was majority leader, he was part of the movement keeping them.
I can't offer him any hope or much encouragement, but I keep him in mind for anything that comes up with me because I feel an affinity with him, and I work with him in connection to this school out here. He's on the board of trustees of.
When he passed a civil rights bill in 1957, there were people who wanted to add to that a poll tax, and he was adamantly opposed to that. And one of the things he would always cite is look at Texas. Texas had poll taxes. Again, there was that argument of using it to fund the elections, and also that it applied to everyone. And one of the things Johnson used to say is, even the governor once, he hadn't paid his poll taxes, and he showed up and wasn't able to vote. It applies to everyone, even the governor. It's not aimed at any group. But mostly, he didn't want to blow up the Senate over an issue that was going to lead to filibusters and all of the segregationists in the Senate and split the party and everything like that in a very difficult time, the 1950s, of which Johnson was the very young leader of the Democratic Party in majority in the Senate. Everything changes when he takes office. He calls the amendment, when it passes, a triumph of liberty over restriction and a verification of people's rights.
And bear him in mind for those things also.
Sure will. Thank you, Spencer.
Thank you, Lynn.
Give my love to Mary.
Waiting.